being able to give some explanation on that. The other question that I had as I started to go through this, and this is sort of a technical question, but as I look at the beginning of the bill under the definitions section, and of course that's at the front of every bill, and it's an important part of every bill because it tells us how we understand the rest of the bill. And there's a part that is confusing me because usually you would have something flow logically, and I found something that doesn't flow logically to me. So when you look at the definitions in the Act, and under Section 1M, under the existing Act, which appears on page 4 and 5 of the printed version, you have a discussion there about record and the definition of a record, meaning a record of information in any form or in any medium, whether in written, printed, photographic, or electronic form, or any other form, etc., etc. But under the Act, what's being added in under that section, which starts talking about a record, is something that is, to my eye, unrelated. So I'd like an explanation of that. What it starts talking about adding in under this clause that talks about a record is a regulation of Alberta, and meaning a regulation is defined in the Regulations Act. M2 would be regulation of Canada, and M3, a service provider. What does that have to do with records? It has nothing to do with records. So you're amalgamating two things together that are totally unrelated in a definition section, which I think is creating confusion. So I'd like an explanation as to why that's happened, because M3, as proposed in the Amending Act, appearing on page 3, and for the purposes of people following along, this is actually section 6. Yes, under the bill, then it would be number 2, section 6. And M3, still under the records section, adds in service provider, means any organization including without limitation a parent corporation, subsidiary, affiliate, contractor, or subcontractor, directly or indirectly providing a service for or on behalf of another organization. So are we somehow supposed to link that this is about records coming from regulations of Alberta, regulations of Canada, and service providers? This is not logical to me, and I'm just wondering if this was meant to be created in a different area, that it was meant to create a completely different section, or if it was meant to flow under the records section. So if I could get that answered, I'd appreciate it. Everything else under that section looks fine to me. And then it just flows on through the rest of the Amending Act, essentially incorporating the details of what's needed to implement the decisions that were made by the committee. And as I say, the decisions were arrived at after a great deal of discussion, and they're all pretty necessary, I believe. So, as I talked about the Patriot Act already, there was also a section to deal with pension and administration of pensions without having to chase the person down and find out about them and deal with them directly. So that would be an issue where the notification clause or the disclosure clause is being exempted and to allow someone to get the work done. It was also some small things like allowing the business title to be attached. So this was around that whole work product discussion. But the organization could give the position name or the title when communicating with a person about whom they have a privacy concern. So they'd be saying, please, you need to speak to the district manager rather than giving the individual's names, and that wasn't a possibility before. The preparation of audits and audited related amendments to collect information, really to allow organizations to collect personal information without consent in the case of former employees as well as current and prospective employees, I never like those sections because doing it without consent, I think, flies in the face of protection of personal information. But you can see that at a certain point it's very difficult to get that consent if you're trying to deal with old files from former employees and things like that. You can't find them. You've stuck that business in an untenable position because they can't get rid of the stuff. They can't do anything with it because they can't get the permission to do it from a long-gone employee. So you can see that, in trying to kind of take the red tape out of this and make it possible to implement it, we've had to forego some of the protections that people like me would prefer to see in there, but I recognize the sort of reality of getting the work done. Some of the other things you've heard other people talk about, the security breaches and the requirement to disclose, a number of things, as I said, for the commissioner. And yeah, I was okay with everything else that was included in this Act, and I spent a lot of time on it. So those were really my biggest concerns around it, is the reasons for not including the not-for-profit organizations. And that very strange section where we're including a whole bunch of disparate elements under that definition of records, which simply did not make sense to me. So having sort of done that on a word-by-word, clause-by-clause basis, I appreciate the opportunity to do that in Committee of the Whole on Bill 54. Thank you.